Staying with us here on NCN for this very important discussion. For this breaking interview, I have the Attorney General and Minister of Legal Affairs, the Honorable Mohibir Anil Nandlall. Minister Nandlall, thank you so much for joining us.
It's a pleasure to be here.
Minister, let's get straight into it. Today, we had some big news coming out from the High Court where the Chief Justice made a very special ruling. Now, just take us through what happened today in the courts.
Well, as you know, the APNU AFC, through their chief whip in the National Assembly, Christopher Jones, filed proceedings challenging the appointment by His Excellency the President of Mr. Clifton Hicken to act in the office of Commissioner of Police. You would recall that at the time there was no leader of the opposition elected. So the post of leader of the opposition was vacant. Article 211 of the Constitution empowers the President to appoint a person substantively to the office of Commissioner of Police or to act in that office. And in either eventuality, the Constitution imposes upon the President a duty to consult with a leader of the opposition before such an appointment can be made. There was no leader of the opposition to consult, and the President proceeded to appoint, and that appointment was challenged. Now, I have often remarked that there is a modus operandi evident in the way the APNU AFC approaches many matters, including litigation. They have this wrong and strong attitude, this approach of attempting to bully their way through on any given matter. So if we are to go back, way back to the no confidence motion matter, in that case, they lost a no confidence motion. Then they were supposed to resign and call elections within 3 months. Rather than accept that position and comply with the Constitution, the Attorney General of the time got a gentleman by the name of Compton Reed to sue the Attorney General to challenge the no confidence motion on the ridiculous proposition that 33 is not a majority of 65 and that Charandas' vote is not valid or was not valid. Recall that they put Charandas in the parliament and they began to question Charandas' qualification to sit in the parliament on the ground that he was a dual citizen. They put him in the parliament, so they are capitalizing on their own wrong. And of course, they are rendering mathematics now illogical by arguing that 33 is not a majority of 65. So that was the basis. And of course, they lost. Fast forward to the 5 months ensuing the 2020 elections. The whole world saw them attempting to rig the elections results with Mingo and then Lowenfield. Each time that they were caught red-handed, and they were caught red-handed on several occasions during that 5 months period, in the midst of their wrongdoing, which was publicly televised in most cases. On each occasion, rather than express contrition and repent, they became confrontational, rushing to the court. On each occasion. And on each occasion, they lost. We are now in government. They caused that 6 months to go by because of their shenaniganism, allowing all the time frame for the convening of Parliament to elapse, the presentation of a budget time frame to elapse, And when we convene the parliament outside of that time frame, and we present the budget outside of that time frame, circumstances brought about by their own doing, they sued the government for presenting an illegal budget. Now there is no opposition leader, through no fault of the president, but because of their own infighting between Harman and Norton. And even after Norton won the contest at their party elections level, they took another few months to make him the opposition leader. Again, the people of Guyana are not at fault. The government of Guyana is not at fault. The president certainly is not at fault. The then commissioner, the then person performing the office of the Commissioner of Police, Mr. Hoppy, he proceeds on pre-retirement leave, so there's a vacancy. The president looks around because the Constitution says that he must consult. There is no one to consult, and the president now has to make a judgment call. The president of Guyana is the commander-in-chief of the armed forces. He is the minister with responsibility for national security and the defense of Guyana. The Home Affairs Minister is the one who has responsibility for the police force. The police force has statutory responsibility and constitutional responsibility for the defense of Guyana, for the enforcement of all laws, for the prosecution and detection of all crimes committed. And the police commissioner has a multitude of functional responsibilities under the Police Act and under dozens of pieces of legislation across the legislative landscape of the country. National security now, internal security are all at stake. The chief defense officer of the land is the president. He is to make a judgment call. I put to the court evidence to show that in 187 years of history in the Guyana Police Force, there never was a vacuum in the office of the commissioner. Now, you don't have an opposition leader. Should the entire country be exposed to a perilous state? Should national security and the safety of the citizens of this country be exposed to perils because of there being no opposition leader? So in those circumstances, the president proceeded to appoint. Completely justified in the circumstances. And although they brought about the situation with the approach that I'm speaking about, once again you see the wrong and strong approach, the approach of bullyism. They sued. When the vacancy in the office of the leader of the opposition is by their own making. I say that to explain to viewers that this was a case that should never have been filed, but they proceeded to file it. That's the arrogance that I'm speaking about, the bullyism that I'm speaking about. So, the judge accepted almost every one of my submissions and rejected almost every one of theirs. In Her Honor's ruling, now judges are normally judicious in the type of statements they make in their written judgment. Judges tend to be very conservative in the language that they use in their judgments. In particular, when it involves the conduct of high constitutional office holders, of which the leader of the opposition is one, the chief whip is one, and the lawyer who appeared for the chief whip, who's a parliamentarian. The Chief Justice used the word disingenuous 3 times to describe their case. The Chief Justice said that their case was incongruous. The Chief Justice said that their case was vexatious. The Chief Justice said that their case was an abuse of the process. And in the end, the Chief Justice said that costs will be awarded, which costs are to be assessed unless an agreement is arrived at by the end of this month. Costs to be assessed can run into millions of dollars. I say all of that to demonstrate to you the type of case that they presented. Now, we put forward to the court several legal arguments supported by judicial authorities across the Commonwealth. We gave the court cases where not only was the person to be consulted in, first of all, we couldn't find a case where the person to be consulted was not in office, because no sensible person would file proceedings in relation to an appointment when the person to be consulted is not present or not appointed. What kind of case are you filing? But they choose to file. I found cases from across the globe to show where there is a person appointed in the particular office that has to be consulted, but that person either was not cooperating in the consultative process, or that person did not respond, or that person showed some degree of reluctance to consult or simply refused to consult. In those cases, the law was made very clear by the various judges who heard and determined the cases that consultation is not a one-way street. Right. You have a duty too to be a willing participant in the consultation process. And that will be borne out in another case that will be ruled upon on the 23rd that concerns meaningful consultation in relation to the appointment of the chairman of the Police Service Commission and members of the Integrity Commission. So they ran and predicated their entire case on a statement that the president made after the appointment. Apparently the president said that the doctrine of necessity would justify his appointment. Now, and we had to confront that because that's what the case was based on. The president is not a lawyer. The president doesn't determine what the law is. The court determined that. What the president meant that in the circumstances, it was necessary for the appointment to be made. And that was the distinction that I drew. That there was no need to invoke the doctrine of necessity. But in the current circumstances, it was necessary for the president to make the appointment. You see, Article 11, 211 of the Constitution empowers the president to appoint after meaningful consultation with the leader of the opposition. So the power to appoint is with the president. After meaningful consultation is a condition upon which that power has to be exercised. If the material circumstances for the realization of that conditionality is not present, it can frustrate the power. The power to appoint is with the president. The other issue that arose, because they wanted apparently their logic in the case was that were the president to appoint Paul Williams, it would have been right. In the very circumstances that the president did not need to consult with the leader of the opposition if he chose Paul Williams. Now that is what it is. The Chief Justice described as a disingenuous argument. If it is not proper for the president to appoint Hicken in the absence of a leader of the opposition, how is it proper for him to appoint Paul Williams? The other important, and that's why the president said you can't cherry pick. The Chief Justice said you can't cherry pick for the president. Whom the president decides to choose to make the commissioner of police either substantive or active or acting is a matter for the president. That is in the exclusive domain of the presidency. The leader of the opposition can't dictate whom the president appoints, but that is what they want to do all the time, and that's the bullyism. The other point that the Chief Justice made clear is that the Chief Justice, upon the submissions we made, examined the circumstances for the absence of an opposition leader. And the Chief Whip is part of the process that appoints the opposition leader. So this is a person who is coming to the court to ask the court to endorse his own neglect and omission and fault the president of the country. So both on logic and on law, their case was absolutely demolished, and the Chief Justice ruled in the manner that Her Honor did. Significantly, recall, as soon as Mr. Norton was appointed, consultations began with him for the appointment of a police service commission, because part of the consultation that the president has to do in relation to the appointment of a police commissioner is to also consult with the chairman of the Police Service Commission. Now, there was also no Police Service Commission in place. So neither of the two persons with whom the president is required to consult were in place. And as soon as the Police Service Commission chairman was in place, we began a process of consultation for the purpose of Mr. Hicken's appointment, who was already in the position, because the president had already appointed him. The point I am making is that here is a president who is trying to comply with the Constitution when you have remedied your vacuous position and you are now appointed. And you know, they rushed to the court to get an order to stay that process. They rushed to the court to get an order to stay the president, attempting now that there is an opposition leader to begin the consultation process with them. So when they are not there, they fault the president for not consulting with them. And when they are there, the president now is attempting to consult with them, they run to the court and get an order and ask the court for an order to stop that process. So these people are of a special pedigree, my brother.
Minister, let me ask you, and that brings us to the next point of our conversation. In the last sitting of the National Assembly, just about $100 million was approved, basically for legal fees for the state. And one of the statements that were made during that process was the fact that it's for mostly frivolous litigation. And there's some sections of the media that's somewhat up in arms about that statement. What are your thoughts on that?
Well, it is a first of all, let me say that I welcome the prominence that my disclosure is receiving in the press, and I am happy that probing questions are being asked because it allows me to explain. The bulk of that money is going towards the payment of legal fees to represent the government of Guyana at an arbitration in Washington, which was instituted by a company that bought out the parking meter contract from the parking meter company. You would recall, and your viewers would recall, that that contract was executed under the previous administration. The company that has been retained is a company of very high international standing, Foley Hogue and Associates. That is the company, coincidentally, that is leading our legal team at the World Court of Justice in respect of the matter involving Venezuela. You would recall that no qualms were expressed in relation to that matter when that firm was retained, and other persons, including Sir Sridat and Carl Greenidge, etc. Now, this may not be a case as important as that, but it is an equally important case for the state of Guyana. As a government, we can't take the approach that because this transaction was entered into by the previous government due to their incompetence and corrupt practices, that we can abandon the state of Guyana and don't represent Guyana's best interest. We can't afford to take such a position. Guyana is being sued for $100 million US. And so long as I am Attorney General, I will ensure that Guyana receives the best legal representation at every forum. And I have no apologies for making such a statement. The people of Guyana, the government of Guyana, and the state of Guyana deserve no less. So we retain the services of that law firm. That law firm has a reputational record before tribunals of that type that would be comparable with any other law firm in any part of the world. We can't leave matters of that nature up to the incompetence of the Georgetown Mayor and City Council, or else we might lose City Hall. Maybe people can levy on City Hall if they win the case. So the government of Guyana is being taken before this tribunal. What is of importance also, and I use your platform to disclose it, now that we have had the opportunity of going through the records and the evidential material in preparation for that international tribunal, we have discovered that the circumstances and the conduct governing the execution of this particular contract by members of the then Georgetown City Council can attract criminal liability. The requisite procedures laid down in the law under the Mayor and City Council Act, regulations and bylaws were clearly not complied with. A few persons, in my humble view, committed fraud upon the council by entering into this transaction without the requisite endorsement, as is mandated by law, of the council. As a result, the Criminal Investigation Department is being activated, and a criminal investigation will now be launched into that matter. So I'm happy that I have gotten the opportunity to speak on that matter. The other matters that money will be used for is, for example, cases that deal with the defense, promotion, and preservation of Guyana's democratic credentials. And I speak of the election petition cases. Those cases are putting Guyana's democracy on trial. We have to get the best possible legal services there as well. And we have to pay for that. Anyone will tell you that you cannot put a monetary value on the democratic credentials of a country. We were once considered an undemocratic country by the world, and we were ostracized, and we were regarded as a pariah by our own CARICOM neighbors because of that horrendous stigma caused by those very people who are again attempting to destroy our democratic institutions and credentials. Guyana must pay to defend its democratic credentials. The third category of cases are the type of frivolous cases that they are filing. And I am describing it as frivolous, and I have the endorsement of the Chief Justice of the country on my side. Her Honor described it as vexatious, a word that has synonymous meaning with the word frivolous. The term is normally frivolous and vexatious. Her Honor used vexatious, I used frivolous. And I'm speaking about cases of this type. You see how karma has it? How it fits into this discourse? So, the President appointed 5 members to the Integrity Commission and a chairman of the Police Service Commission. They sued all those persons in their personal capacity. Now, is it fair that those people are dragged before the courts simply because they have evinced an intention to serve their country and to serve their people? Those people now must be allowed to incur expenses to retain a lawyer. I can't appear for them. They have been sued not in their capacity as the office to which they were appointed. They are sued personally.
Okay, right.
The state has a duty, the president having appointed them, to represent their interest. Unfortunately, taxpayers' money have to be used, and the government must not be faulted for that. Those who are bringing these frivolous and vexatious litigation must be faulted for that. Now, in planning a budget, I could never in my wildest imagination, well, I should have, because I've been dealing with them for a long time. So I accept responsibility for not predicting such ludicrous filing of cases, or the filing of such ludicrous cases. And that is why we need supplementary. And there is not one, I only give you one example. I can go on to point out every day. And the truth, I also see them make a comment about procurement.
Right, yeah.
Now, first of all, these lawyers who are being retained, they are complying with the procurement process. But you can't go through the elongated procedures because the cases are filed, and within days you have to appear before a court. So you do it ex post facto, right? Because this is services that you're retaining. You have to retain quality lawyers, or else you end up getting cases that was filed by Christopher Jones. That is the quality of representation you want us to affix the government of Guyana with? No, at least not when I'm Attorney General. The people of Guyana, the state of Guyana, the government of Guyana must get quality representation whenever they are sued. And it is my responsibility, I think, to ensure that that is done. And that is being done lawfully.
So let's just stick a little bit on the tendering for for these legal services, as you mentioned. What exactly is the process, or what does that process look like for these legal services?
You can't go out in advance and tender for these things. It's not possible. You have to retain. So lawyers are retained and procedures are complied with after that. Services of lawyers are retained. You know, at the beginning of the year, I have a complement of lawyers, and these are the lawyers that, in the event they are needed, these are the set of lawyers whose services the state will engage when the circumstances arises. And that is how it has to be done. There's no other way. And you can't look at, if you want quality service, good lawyers come at a particular rate. Now, I can get lawyers of the quality who are filing cases against us, like the one filed today. You know, they say you pay peanuts. You know what you get. I don't want that for the people of Guyana. I don't want that for the government of Guyana. So we retain quality lawyers. Unfortunately, they come at a particular price. That is how the world operates. You have cheap clothing. You have expensive clothing. There's a reason why. There's a differential in price.
AG, as we wind down our conversation, let me ask you, in relation to what is to happen next, in relation to these litigations that are coming, what are some things that are coming up that the public can expect?
Well, you have, as I said, in keeping with the modus operandi that I spoke about at the commencement of the program, that is to say, the wrong and strong and the bullyism, we have the Mace case, where they behaved in the most disorderly manner, in the most unruly manner, in the most disgraceful manner. They flouted orders from the speaker to take their seats. They completely ignored the speaker, several mentioning of their names. They descended into the well of the parliament, a sacred area. They attempted to intimidate Dr. Ashni Singh from discharging his functions as a minister speaking on a bill. They blew whistle and were shouting like lunatics. They then grabbed the mace and attempted to run with it out of the National Assembly. They broke it in the process. They assaulted the staff of the parliament. They dragged a staff on the floor of the parliament. They labeled him a house slave. One of them went into the control room and destroyed the loudspeaking apparatus of the parliament. And after doing, and all of that is streamed live, the whole world watching this horrendous and horrible spectacle. And rather than try to forget that incident, try to sweep that incident under the carpet as being an irrational moment. I guess we all have moments where we lose rationality. You know, these people file a case against the government. After doing what I just explained here to you, they sue the government, claiming that Manzoor Nadir, the Speaker of the Parliament, did not permit them to speak. I should really make some of these affidavits public. Let people read what these people are saying on the oath. That they conducted themselves in no way whatsoever in a disorderly way. Absolutely. Absolute denial. They did nothing wrong. That they behaved normally and they were prevented from by the speaker from speaking. They have become the victim. So we have that case. They have been suspended by the parliament for their conduct. And there is no parliament on planet Earth who would not have sanctioned members for that type of behavior. No other parliament in the world would have done differently. No parliament. And sanctions include suspension. These are all powers of the parliament, you know. When you are suspended, your pay is suspended. And that is provided for in the law. In the law. In the Emoluments of Parliamentarian Act, there's an act of Guyana, a law of Guyana, that speaks to the fact that when parliamentarians are suspended, they are not to be paid for that period of their suspension. Again, they sued the Attorney General, they sued the Clerk of the National Assembly, and they sued the Speaker. So again, conveying the impression as they are victims. Now, that is what I describe as vexatious, frivolous, nonsensical, specious, unmeritorious litigation which concatenate to constitute a mammoth abuse of the process of the court. I see the Kaicho News saying somewhere that I am crying crocodile tears because I was filing cases when we were in the opposition. But I don't know what kind of crocodile tears I am crying, because I'm not. I file cases, yes, and I have a track record supported by court orders that vindicate me filing those cases, because I won almost all of them. Almost all of them. Beginning with the chairman of GCOM's appointment, beginning when they tried to start a new registration process with the list, beginning with how many cases are filed for the rice farmers, how many cases are filed against their housing department when they tried to take away core homes, when they tried to seize the Red House from the Cherry Jagan Research Institute, when they fired how many public servants without paying them their due remuneration under their contracts, and I can go on. When they give directions to the Police Service Commission to halt promotions, when they give directions to the Public Service Commission to halt promotions, all of them I won. Compare that to what they're doing now, and there's no basis to compare. So you have frivolity on one hand, and you have meritocracy on the other hand. They're not the same thing. They are actually the opposite. And as we are on the use of money, the then Attorney General for the no confidence motion case, I said it before and I'm going to say it again, used over $25 million of public monies to pay 2 senior counsel to appear for Compton Reed to sue him, the Attorney General, for the no confidence motion case. And I want people to absorb that. The Attorney General, taking public monies, pays 2 senior counsel to represent Compton Reed to sue the Attorney General to set aside the no confidence motion. You want a more vulgar use of public funds, if that is not criminal? That is the parity. Well, not the parity, but that is what you have on one side of the divide against what is on the other side of the divide. So there is no basis, my friend, to compare, and I hope those who are writing in the newspapers will take note of what I'm saying now. And if they want the paperwork, I have it. In the year 2019, the Attorney General spent $100 million in legal fees. And He didn't have a parking meter case of international importance. He didn't have any of these type of cases. Ordinary cases he had to deal with. Nothing of an international nature. 100 million he farmed out. Today, look at who appearing for the Attorney General. The Attorney General is appearing with staff from the Attorney General chambers. It's only where other agencies are sued, where the Attorney General cannot appear, and when other persons are sued, that it would be improper for the Attorney General to appear, that private counsel are retained to represent those agencies and those persons. This Attorney General don't ever back down. And I don't need anybody to represent me. I represent myself and I represent the government of Guyana. I am the Attorney General. Not like my predecessors who used to have to hire lawyers for appear for them. I don't do that. If I could have gone to America and appear in the parking meter case, trust me, I would have done that. But I can't do that. I don't know those procedures. I am not there. You have to have lawyers who are in that locality and jurisdiction to appear before that tribunal because there are special rules and regulations. I also am competent to know when I am incompetent to act. And that's a very important distinction that a lot of people don't appreciate. You must know when you do not know. You understand?
Yes, sir.
A lot of people don't understand that distinction.
AG, as we finally, and just so that we can end on this note, in the National Assembly on Friday, one major bill was tabled, and that is the Constitutional Reform Commission bill, or the motion rather. Tell us a little bit about the need for that and what is going to happen in that regard.
Well, as I often said, the Constitutional Reform Committee of the National Assembly shall be the driving force to push constitutional reform, a manifesto promise of all the political parties in the National Assembly. We on the government side promised that we will do so by a law, and that law will establish a broad-based commission, and that commission will plan its own agenda. But that agenda must be based upon public consultations for constitutional reform. We promise that that law will establish the composition of the commission and will empower the commission to enlist the services of experts whom it may consider necessary, that it needs to discharge its functions. All of those are contained in the law. The broad-based commission include, as we promised in our manifesto, 50% of the commission shall comprise of the government side in the National Assembly and the opposition in the National Assembly. So that's 50% of the commission. The other 50% will come from broad-based civic organizations or civil society organizations, if you wish. So you have, and we structured it in very broad way so that you don't bias towards any particular nominee or any particular faction of civil society. So you have a representative of labor. You have a representative from the private sector commission or the private sector. You have a representative from the religious organizations. You have a representative from the Guyana Bar Association or the legal profession, I believe. You have a representative from the National Tushao Council, that's the legitimate body representing Amerindians. And it lists various organizations of that omnibus description. So, and the president appoints the chairperson of the commission. Of course, that has to be a person duly qualified to preside over such a commission. And once that bill has been laid, once Parliament resumes, hopefully it will be debated in an expeditious manner, and we will move ahead to establish the commission, and that commission will drive the vehicle of constitutional reform over the next 2 years or so. Whatever the mandate, whatever the time frame is, will be determined by the commission itself. The point I am making is that we promised that it was not going to be interfered with, dominated by, or driven by executive government. That's the important thing. So that whatever is produced, it would reflect the will of the people of Guyana. The people of Guyana must determine the type of constitution which they want to govern them.
AG,
And that is what that bill is intended to achieve.
definitely. AG, thank you so much for taking the time to talk with us on these very critical matters.
Thank you very much. It has been a pleasure to be here with you.
That has been the Attorney General and Minister of Legal Affairs, the Honorable Mohibir Anil Nandlall. I'm your host, Shaquan Gill, saying bye for now.